talk is about force majeure, that hot topic of dinner table conversations. And I've given it the subtitle, You Can't Always Get or Give What You Want, which for those who know our local distinguished senior business and property court judge is a reference to His Honour Judge Kramer, who's always talking about the Beatles and Stones and shoehorning in a reference to them in the talks he gave. And I thought I would do that in this one. The mistake I made was in choosing that subtitle without actually knowing any of the case law, the recent case law. And I discovered, in fact, there was very little of it, surprisingly little. So some of the jokes and metaphors and conclusions I draw are a bit shoehorned in at the end. There is a good reason for that. The starting point, before we get on to force majeure clauses, is the doctrine of frustration, which we'll all have covered when you were doing contracts at college and university. Something which is actually talked about and taught, but in practice doesn't become relevant, in fact, very often. But the starting point is the common law doctrine that a contract may be discharged on the grounds of frustration if something occurs after its formation which renders it physically or commercially impossible, and that's my underlining, to fulfill the contract, or it transforms the parties' contractual obligations into radically different obligations from those originally undertaken when the contract was formed. Physical impossibility is pretty straightforward. If it's the year is 1883 and you contract to go to Krakatoa, to the port there, to pick up some substances, some coal or guano or whatever's there, and then discover not only is there no port, but there's no Krakatoa to go to, that's physical impossibility, very straightforward. Commercial impossibility is a much more difficult and frankly nebulous concept. Is a contract where it suddenly becomes 10 times or 100 times more expensive for you or for the other party to perform their obligations impossible? Well, probably not. Especially not in the modern age when there is so many hedging and financial instruments people can take out when contracts are formed to prevent those types of risks arising. And the second element or possible way frustration arises, transforming a party's contractual obligations into radically different obligations from those originally undertaken. Well, that's an easy phrase to write down. In practice, that can be a very difficult and hard judgment to make. And it will not surprise you to hear that reasonable people, reasonable lawyers, reasonable judges can come to different yet reasonable conclusions about whether contractual obligations have been radically transformed or not. Suffice to say, it's a common law doctrine, and in England, Wales, you can contract your way around that. As I said there, smart clients, smart lawyers anticipate these possibilities when drafting commercial contracts. Force majeure clause is one type of protection you can provide, hardship clause is another. Suffice to say, not every commercial contract will have a force majeure clause. If somebody's selling a chip shop in North Shields, I don't think it would be an act of professional negligence not to have a force majeure clause there. If, however, you're dealing with a large commercial contract, maybe one over a long period of time, maybe years, and especially if it's got an international dimension, I would have thought that, in fact, that any well-drafted contract would have an appropriately drafted force majeure clause. So what is a force majeure clause? Stay next to the mic. Contract term by which the party affected by the force majeure event is entitled, usually after the occurrence of a contractually specified event outside their reasonable control, to do, and I've given 3 examples and sort of a Goldilocks options here, hot, cold, and right in the middle, parties to specify what the consequences are. At the most extreme end, there could be a cancellation of the contract, which could give rise to all sorts of difficult restitution issues if somebody's handed over the money before they've actually got the performance. An intermediate step might be for the party affected to be excused from performing their outstanding obligations under the contract. Again, that could be quite a serious effect if that excuse from non-performance is to be permanent. And then the lowest step, I would have said, was to suspend the party affected's obligations so long as the event remains ongoing. But ultimately, it's for the parties, the contracting parties and their lawyers, to work out what the consequences of a force majeure event should be, and then they'll have to live with that consequences. The warning, courts in England and Wales treat force majeure clauses like they treat other clauses in commercial contracts. They will, generally speaking, they'll use the commercial common sense, but they will, generally speaking, focus intensely on the wording actually used. And obviously, heaven help you if you get the wording wrong. So great care needs to be taken with the wording. Wide enough for us, narrow enough for them. If you think you're the party who might be affected by a force majeure event, make sure that the wording of the contractually specified force majeure event is wide enough to consider what you think might realistically happen. But remember, by the same token, this is probably going to be a neutrally drafted clause, and so as wide it is for you, it's going to be as wide it is for the other side as well. So you need to be careful. As I said, when I was thinking about this talk, I naively assumed that after COVID there'd be a ton of cases because the pandemic arising from COVID-19 certainly wasn't one everybody's expectations in 2019. And I thought, well, goodness, by 2022 there must have been loads of cases brought and decided where force majeure was relied upon COVID-19, and the effects to deal with it would fall under, or arguably not fall under, a force majeure event. But in fact, I could only find in the last 18 months or so, from January 2022, 3 cases which I thought were of particular interest. So I'm giving you the top 3 cases. I'm also giving you the benefit of the middle 3 cases, and I'm also giving you the 3 least interesting cases, because there's very little case law out there. Mur Shipping. The facts are relatively straightforward. Obviously, I'm giving you the condensed summary, which for the bits relevant to force majeure. RTI chartered Mur Shipping to ship 10,000s, I think it was hundreds of thousands of tons of bauxite from Guinea to Ukraine. I made the precaution, since I'm giving this talk, of actually looking up bauxite to find out what it is. And it's got nothing to do with coal, which I assumed it was. Apparently it's a rock, and it's a rock which you're most likely to find aluminium in. So it's obviously very commercially valuable. And Guinea, again, my geography isn't so great. I double checked. Guinea is a country in West Africa, to be distinguished from Papua New Guinea, thousands of miles away. So that was the basic contract. The key point for the dispute was that RTI was contractually obliged to pay Mur for that shipping service in US dollars, and only US dollars. And as I said, this was a classic contract where you'd expect a force majeure contract clause to be in there, and there was. And the key point for present purposes is what was excluded from being falling under the contractual definition of a force majeure event. It was an event which could be overcome by, quote, reasonable endeavors by the party affected. April 2018, US Department of Treasury imposed sanctions on Russian oligarchs, which affected RTI because its ultimate owner was one of those Russian oligarchs subject to sanctions. And in April 2018, Mur, which had basically decided that this contract was no longer as commercially advantageous as it had originally been, it thought had better options, sent a notice of termination saying that because RTI could no longer lawfully pay Mur in US dollars, and Mur could no longer lawfully receive those payments, the contract was frustrated. And its case was that the contract was suspended while that remained the position. For those who've had a quick look through my handout, you'll know already that this dispute went through 3 rounds of litigation. And the winner, bob back and forth. Round 1, international commercial arbitration, winner was RTI. The relevant holding being that Mur couldn't rely on this force majeure event to suspend its contractual obligations because the alleged FM event, the inability to lawfully receive US dollar payments from RTI due to US sanctions, could be overcome by accepting euros instead, which in fact it had done in the past. So far so good. That would have been the final outcome, but there was more to come. There was an appeal to the High Court under Section 69 of the Arbitration Act, 1996, where there's a very limited right to appeal against arbitration judgments if there's an error of law by the arbitrators, and this is what was argued. And this became before Mr. Justice Jacobs, and the winner was reversed. The winner was Mur this time. And his essential holding was that it wasn't in dispute, and it wasn't in dispute, that the contract required RTI to pay Mur in US dollars, not euros, and the reasonable endeavours clause, that part of the definition, didn't require Mur to accept a non-contractual payment from RTI instead of contractually specified payment in euros instead of dollars. Now, I'm just stopping here. I think a lot of commercial practitioners, a lot of judges looking at this would think that's actually right, or it must be right. But again, RTI, it obviously won once, had the bit between its teeth and gave it another go before the Court of Appeal. And this time they won, but I'd note by a majority decision, two of the lordships agreeing with RTI, one of them agreeing with Mr. Justice Jacobs. And what they held was that the correct answer depends on the construction of the relevant FM contractual term, which again is the theme of all of these cases. That is the starting point, and if you're not careful, you don't take care, that will be the end point. They made a finding, or effectively a finding, I think, from the arbitrators that Mur's acceptance of the proposal to be paid in euros, and key point is for Mur to bear the costs associated with converting the euros to US dollars, would overcome the force majeure state of affairs. And they found, the Court of Appeal found that accepting RTI's proposal required no effort by Mur. I have to say, just pausing there, I find that if it's to be taken literally, it must be almost certainly wrong. I'm sure there would have been some effort, even if it was only administrative effort, but I'm assuming, in fact, the test there was a practical one, a de minimis effort, really nothing of any commercial consequence at all. And so applying those findings and going back to the fact that, again, this was an appeal in relation to what the arbitrators had originally done, Court of Appeal concluded 2-1. Arbitrators hadn't erred in law in concluding there was not an FM event, because what happened could be overcome by reasonable endeavours by Mur. So again, my corny joke, Mur got what it needed, definitely not what it wanted. So at the end of the day, it got cash, contract carried on at least after that Court of Appeal judgment, as far as I'm aware, but it didn't get the out that it was looking for. Another case, more recent case, which is directly COVID related, is this case, European Professional Club Rugby and RDA. And I think this was the outcome of this case, possibly because it simply wasn't appealed, was a more conventional and predictable outcome. EPCR, as I've called them, I define them as the governing body and organiser of two major European rugby competitions. And sometime before the 2018-19 season of those competitions, EPCR licensed the TV and media rights, obviously right to watch it, and presumably to stream it, to RDA for 4 seasons. 4 seasons there, and bright observers will note they overlap the period both before and after COVID. And obviously it was RDA's intention, having spent or being obliged to spend considerable amounts of money to get these rights, to sub-license those rights and make its own money. March 2020, a month which most of us will remember very well, COVID-19 kicked off all over the world, big time. And EPCR suspended the quarterfinals of the Euro rugby competitions, obviously pretty difficult to have social distancing in a rugby match, and also notified RDA of its intent to suspend the semis and the finals as well. What it didn't propose to suspend was RDA's obligation to pay the licensing fees, which you might think was taking the mickey, but that was the situation. RDA, understandably miffed about being asked to carry on paying for a key service it wasn't getting, stopped making the license payments, and I think about 3 or 4 months later, served notice of termination of the media rights agreement, relying on the force majeure clause. And this matter came on before His Honour Judge Pelling, QC's, I suppose now KC, sitting as a Deputy High Court Judge, and he found, I have to say, I think rightly, found for RDA 3 key points. RDA's motives for terminating the media rights agreement were legally irrelevant, a point which runs across, I think, all commercial litigation, not just to do with force majeure events. You've either got a right to do something, generally speaking, a contractual right, or you haven't. And generally speaking, if you've got a right to do something, you have a right to do it. No obligation of good faith and fair dealing under English law, the way that there is as a matter of course under civil law jurisdictions in Europe. And what His Honour Judge Pelling held was that the only question that mattered was whether, as a matter of construction, the party seeking to rely on the FM clause was entitled to terminate the agreement based on the events that happened, and he concluded as a matter of construction, given those events, it was entitled to terminate. So in that case, RGA got both what it wanted and what it needed, the termination of this contract obliging it to make those license payments. The third and final case was by one of our distinguished local business and property court judges, His Honour Judge Klein, who's mainly in Leeds. And this case, PD Teesport and P&O North Sea Ferries. PD Teesport was represented by, I would say local, but now international and local law firm Womble Bond Dickinson, and had a successful outcome. The facts were straightforward again, in summary at least. Teesport operate the Teesport freight port in Teesside, March 2021, and I'll come back to that date in my closing. Teesport entered into a contract with P&O North Sea Ferries. Complicated contract, lots of terms, but the key one for present purposes, P&O had to make payments to Teesport based on a minimum volume guarantee, a formula. And it wasn't in dispute that because of events that happened, P&O didn't make the contractually required payments. And Teesport, thinking, as it turned out correctly, they had them banged to rights on this, issued a breach of contract claim. And P&O's defence was threefold, relied on, tried to identify three force majeure events. One, because of COVID-19, P&O customers had cancelled or reduced their orders. Two, social distancing requirements had limited the number of vehicles P&O could carry. And three, P&O customers had been unable to adapt to the post-Brexit transition arrangements. So that was its case. And it came on for hearing on Teesport's summary judgment application, and he held for Teesport. Summary judgment, the first thing that Teesport had to do was prove that it was entitled to these payments. That was pretty easy. Contract said so, no dispute that those payments hadn't been made. The real issue on summary judgment was the issue of whether this force majeure defence P&O was seeking to run had a real, i.e. non-fanciful prospect of success. Again, His Honour Judge Klein focused fairly and squarely and correctly on what the clause provided. The two conditions had to be satisfied in order for the contractual FM event, defining clause 12.3 of the contract, to operate to kick in. One, Teesport itself must have been affected by the FM event. And two, the effect on Teesport, that effect, must have been the cause of P&O's inability to transport the units. And when that was issues decided, His Honour Judge Klein had, I think, documentary evidence plus a witness statement from somebody from Teesport saying this didn't affect us at all. Clearly puts a burden of proof on P&O to show that it had a real prospect of proving that it had affected Teesport. And what His Honour Judge Klein held and decided after reviewing the evidence which had been put before him was that P&O's case was based not on evidence, but on assertion. There was just no evidence, at least no concrete evidence, that any of those three matters relied upon had indeed affected Teesport. The council, and I feel for them because many of us have been in a situation where you can't put forward the case you might want to put forward because of the evidence you've got or not got, and you do the best with what you've got. Counsel for P&O sought to argue that this omission in the evidence, this gap, could be dealt with by judicial notice. You might have some sympathy with that. COVID-19 and its effects around the world, in Europe and in the UK, were certainly notorious and certainly worldwide. And His Honour Judge Klein was prepared to accept that there might be some scope for judicial notice. He was prepared to accept that he could take judicial notice of the fact that COVID-19 and indeed Brexit had both had a detrimental impact on individual travel arrangements and travel volumes. How could it possibly not? But of course, that was rather putting the issue at too high and general a level. The real issue, the key factual issue, was the effect that the COVID-19 and Brexit had had on Teesport. And he just didn't accept that he could take judicial notice of how COVID-19 and Brexit had impacted the operation of seaports in 2021, and this particular seaport in particular. And so for that reasons, he found that the P&O's force majeure defence had no real prospect of success, and therefore there was no reason not to grant Teesport summary judgment on the entirety of the claim. My conclusion from this, or the outcome, P&O got neither what it needed nor what it wanted. And I say anyone surprised, for me the key event was March 2021. By the time we all knew about COVID, we all knew about Brexit, so I would frankly have been surprised if it made it out. But it had the effect.